is reserving 21 minutes and rebuttal for 3 minutes. BM26 respondents. Speaker 1 is reserving 20 minutes. Speaker 2 is reserving 20 minutes and rebuttal for 5 minutes.
I extend my cordial greetings to this honorable bench first and foremost. I request the honorable bench to grant me permission to address this bench collectively as your lordships. Much obliged to your lordship. If your lordships are well versed with the facts, the council seeks permission to approach with the issues of the case. Issues, your lordship, or facts?
Just a brief narration of the
A
facts.
crisp of the facts.
Yes.
Much obliged to your lordship. The union government have approved a project called Hydro Mine Nexus, which is a construction of dam and extraction of minerals, your lordship. And along with this, your lordship, this was granted EC also. And this granted EC was without consideration of public consultation, which are mandatory by statutes. And later in an independent research, the people as well as the founder founded that there is a clear violation of rights as well as forest rights too. So this petition is brought before this Honorable Supreme Court under Article 32. So this is the summary of the facts, your lordship. If your lordship is satisfied, the council seeks permission to approach with the issues. Can I proceed with the issues, your lordship? Indeed, your lordship. Your lordship, first issue fundamentally deals with the legality or the question of environmental clearance, whether it was constitutionally valid or not. That is the first issue, your lordship. First and foremost, I would like to draw your attention towards the EIA notification as well as the act also, your lordship. Section 3 and section 5 of the Environmental Protection Act, along with section 7, Clause 3, subclause 2A of EIA notification, your lordship, in which it is very clearly mandated that all category A projects brought by the government necessarily needs a consultation, your lordship. Now, in this particular case, the first problem with this issue is that the environmental clearance granted by the government was done without fulfilling the criteria of basic quality which is needed, basic forum which is needed, your lordship. Further on, this issue will be discussed in 4 limbs, your lordship. First is the procedural irregularity in this particular matter, your lordship. And further on, your lordship, the closest proximity of the land required for consultation. The law mandates that it should happen in a closest proximity. Now, the point is, there is a so-called consultation which was conducted, which will be contended in the next grounds also, your lordship. That was not a consultation itself, because consultation is required from Gram Sabha as well as from the Ministry of Forest. Both of this was not called because Gram Sabha should be called on its individual capacity, but district collector organized a meeting here in this facts. So both the condition of Gram Sabha is also failed, and along with the Ministry of Forest was neglected like that knowingly. So the consultation is a failure now, which shows us very clearly there is a procedural legality problem here. Secondly, what is the law saying very clearly is the usage of the term called shall. Shall means there is a direct implication on the state to do a consultation. It does not have.
Which is the provision that you are?
I'm referring to section 7(3)(a) of EIA along with section 3 and 5 of Environmental Protection Act.
373A.
1 minute, your lordship. Your lordship, before that, I will submit my compendium before this honorable court. Indeed, your lordship. So I apologize for the inconvenience caused, your lordship. And I was referring to notification 7 clause 3A, your lordship. And it is written here A public consultation refers to a process by which the concerns of local affected persons and others who have plausible stake in environmental impacts of the project or activity are ascertained with a view of taking into account of all material concern in project or activity designed as appropriate. All category A, the word is very clear, your lordship, all category A and category B1 projects and activities shall undertake public consultation. Now, the point is, here also, your lordship, they were trying to take the exemption. The state is trying to hide itself by taking the exemption called national security, which is challenged in the upcoming issues too, your lordship. So, first thing, there is a breach of law, your lordship. That is the first thing. And when we speak about consultation, your lordship, Nagoya Protocol is something which was abandoned by the High Court for not considering. So, this particular protocol says 4 elements as basic for consultation. Firstly, there should be F. F means free, your lordship. So free here, it has been breached very clearly, your lordship, because there is a clear, 1 minute, your lordship. There is a clear coercion, intimidation, as well as manipulation, your lordship. How I prove, your lordship? A village headman was called, and it was said that it will given some amount to him, and an employment opportunity will also be provided. That goes against the very principle of consideration itself. Consultation.
What is the basis of your submission? That a village headman was called, he was coerced or whatever.
It is in the facts itself, your lordship. Yes, your lordship. And second, the affidavit given by the counsel for the petitioners in annexure number B very clearly says that whenever the victims, that is the indigenous people of this country, go before the interpreter asking for a help, translation, the interpreter just said, the government will take care. He was not translating at all, which affects the third condition of getting informed. And the fourth is also, your lordship, fourth is consent. Consent, FPIC. The fourth is C, the consent. And how it has been affected, in paragraph number 5 of the memorandum, you can see in page number 13 of the memorandum, you can very clearly see that 62 were present, 14 members affirmatively assented, 17 explicitly dissented, 31 remain silent. Now, what happens, your lordship, is a very important question for arbitrary exercise of power. What happens here is, the dissenters 17 out of 17, 12 were arrested by a fake charge, and they were put into the prison. Now, the point is, dissenters are being arrested, and it was also taken note, your lordship, very important point is that it was considered to be anonymity in consent. They recorded as it is a complete consent in its name.
All these conditions are precedent for preparing report, and after considering the report, permission was granted, all work commenced, everything done.
Now the report,
where were you at that time?
The report itself is a malified.
Only after this incident,
Indeed,
you came forward. It should have been taken care of at that stage.
On prima facie itself, your lordship, that is my contention. On prima facie itself, the counsel for the respondents fail to protect the very basic element of consultation.
You waited till this incident occurred.
No, your lordship. This had directly implied in breach of fundamental rights, which I will discuss in second issue.
You are an NGO. If
Indeed.
you are really concerned about the safety of the people and environment, you should have taken up the matter then and there.
Your
Is it not?
lordship,
The authority?
as I discuss further, your lordship, I will give light on what fundamental rights are breached, on which way it is breached.
The question is to you're focusing entirely on the consultation aspect.
Yes, indeed.
Now, based on the consultation, there was a report on which the tribunal
No.
acted, on which the tribunal also acted,
Indeed.
and the consent was given,
Indeed.
challenged before the High Court.
Indeed.
And at this point of time, can you seek to set aside the entire process for focusing only on the consultation, on the flaws in the consultation?
Not at all, your lordship. It was went before the judicial forum. I would like to clarify it, saying that we had approached the NGT, we had approached the High Court also. And as a last resort to our remedy, we came before this apex court.
That is after this incident.
No. During this particular incident taking place, that is after this consultation and all these things are problematic, we went before the Honorable High Court as well as the NGT, which decided against us. So at last, as a final resort, we are coming before the Supreme Court. After this particular problem resulted in a violation of fundamental right. The consultation you're saying.
Since you are not consulted, you have immediately approved.
Why did you wait till the landslide?
Landslide.
I getting it, your lordship.
So then what is the answer?
The factual matrix are set in that way. Your
Because
lordship.
the government spends huge amount.
Indeed, your lordship. But according to facts, what we know is, your lordship, this was approached to the NGT as well as the High Court also, your lordship. That is something which is with the factual matrix.
The approach only after the
Landslide.
After certain fundamental right violation,
So then there was some violation.
consultation was the violation. Now later it had evolved into various fundamental right violation.
Whenever there is a violation, you have to approach the court at the earliest opportunity.
Indeed, your lordship. That can be taken.
You have approached earlier, even by you have been avoided.
Indeed,
The amount is different. So
indeed, your
you
lordship.
have been saved.
Indeed, your lordship.
Was
Now,
any
in that year, the case is sustained huge loss.
Indeed, your lordship. I understand it, your lordship, but I would like to draw your attention to a very important judgment given by the Supreme Court. In paragraph number 3 of the memorandum, that is referred in page number 12 of the memorandum, it says in the case of Hanuman Lakshman Ansokar versus Union of India, which is a 2019 judgment, in which the Supreme Court said that the very element or the consultation is not just a procedural lack. It has a constitutional value, says the Supreme Court.
You admit,
Indeed,
but how do you account for the delay?
indeed, your lordship. I acknowledge that particular question, your lordship.
you may take it, you invoke Article 32 after the landslide and all. Of course, we'll consider in that perspective.
Indeed, I get it, your lordship. Now, further on, your lordship, I would move to your attention towards the government's functioning was unlawful, your lordship. How do I say it? The facts when it introduced that the government was planning to bring this forum, they said it as this is a methodology adopted for national strategy. This is a national strategy they proposed. Later, when the NERA granted its approval, it is still said as the national strategy, your lordship. But while considering the facts, for considering the law, respondents had intendedly brought it under 731F, a classification for national security, which can be exempted from consultation. Now, my point is, the point before this honorable court to question before the respondents is that what made the respondents attribute this particular thing as a national security? That is a question which the honorable court should put before the respondents, your lordship. Further on, your lordship, it is important for us to understand that EC granted was on incomplete and legally defective basis, your lordship. Now, where this location is located, where the construction of the dams, the proposed location is located is where there is a seismicity prone, your lordship. Seismicity is a place where there is earthquake possibilities are more, your lordship. Now, the point is, traditionally, the government will inspect it and they will give a report called mandated detailed seismic hazard assessment, your lordship, which is referred in 13th page, 7th paragraph. The report is called as seismic hazard assessment, which is mandated by the International Commission on Large Dams. Now, the point is, the government, if this question is put forth before the government is saying that that was not needed for EAA. Now, my point is, your lordship, let us keep aside the EAA perspective. There is a big question of protection and safety of the people, but the government still holds on to saying that it is not mandated. And further on, your lordship, it is important for us to understand that an inconsistency is found in the government policy. This environmental clearance is granted on 4 merits, I said. Now, third is inconsistency in government policy. How do I say it is because the state in annexure H31 says that hydro mine project is tier 1, your lordship. At the same time, the state is also saying that we follow a policy which says that there is no deforestation, a 0% deforestation. Now, how can two policies can go to hold together? Now, this is where the Supreme Court was very clear in observing the state of Bihar versus Project Utstava. This is a case decided on the year 2023, in which the Supreme Court said that the state cannot hold inconsistent positions in international as well as in domestic forms. Your lordship, and another important thing which we all know is that state is taking the role of guardian, your lordship.
EC was granted based on a report submitted by GeoConsult.
Indeed.
The report of GeoConsult deals with this seismicity aspect also.
Indeed, your
Now
lordship.
then, why do you say that that particular aspect was not taken into consideration?
Once again, your
Yes.
honor.
How can it be contradicted?
That's right. The report by GeoConsult, that is the basis on which the EC was granted.
Indeed.
GeoConsult has considered this aspect of seismicity specifically in its report. And as long as the report is there, it is not under challenge. How can you say that?
No,
that
sorry for interruption, your
Yes.
lordship. There was no that seismicity study was not conducted. It is nowhere conducted. So that is the problem before this honorable court. When you plan a construction like big like this in an ERR, that is also
What
important.
is the basis of your submission now that was not there in the report? You have a copy of the report with you?
EAA, your lordship.
GeoConsult?
EAA is there, your lordship. Annexure number E.
No, when you say that, on facts, when you say that there was no consultation on this aspect,
Okay.
or there was no consideration of this aspect, you should be ready with the materials.
Ah,
also.
indeed, your lordship.
Yes.
Which I am saying that EAA is present, which was submitted by the government. Now the report is saying.
No, that the very basis for consideration is the report also.
Report is,
That is one
I
of
would
the
like to draw your
major
attention
aspects that
towards
is taken.
Annexure C, your lordship.
Yes.
Annexure C deals with the independent survey of Mrs. Vega, someone who is involved in
So
independent
let's not
research.
jump to other documents. We are on a particular document, you give your answer based on the document itself. I am on the report submitted by GeoConsult.
GeoConsult
and
did
you-
not speak about it. Annexure A, your
So
lordship.
please take me. through
Annexure A
Yes.
speaks about hydrology,
that. Yes,
fauna,
yes.
population to be displaced,
Mm.
tribal and forest dwelling communities, and greenhouse gas assessment. In greenhouse gas assessment also, it's important to note A6,
Yes.
A6 paragraph of the report, EIA. It says that there is a there is a material gap is there.
Yes.
The study did not assess even the biogas assessment. And along with that, seismicity report was not filed. That is my contention in Lordship.
Okay.
So both biogas as well as seismicity was absence.
Yes.
And further on, your lordship, if your lordship is, I would like to draw your attention towards paragraph number 17, in which the Supreme Court decided Vanashakti versus Union of India, 2024 judgment, in which the Supreme Court said that in disregard of mandatory statutory safeguards cannot be sustained merely on the grounds of administrative convenience, your lordship. Why I say this at last is because whatever questions we put forth before the respondents, they are simply going to say that we have complied with the EIA. Second is that it is an economical dependency. Now, my point is this all cannot be a reason for the mandatory provision of law to not comply with. If your lordship is satisfied with this argument, I would like to proceed with the second important issue.
Yes. Before I'm still on that, when you give a fact and if it is found that the fact is incorrect,
Which
then
fact
that
you
will go against your argument, will it not?
No,
please take GeoConsult report once more.
I had taken it, your lordship.
Yes.
Tell me, your lordship.
And I'm on paragraph A3. That is
A3,
baseline environment conditions.
A3, your lordship.
Yes.
Okay, your lordship.
You got that?
A3.1,
It's
3.2.
A 3.1.
3.1.
3.1.
Yes, your lordship.
Yes. Then it's located a perennial. You read that particular portion?
The project site is located on Verdant River, a perennial river originating in Verdantia Island at an
Yes.
elevation of 2,100 meters.
Yes.
A mean flow, your lordship, yeah, 312 meter per seconds. The Verdant River is a tributary of transboundary Aquaria River system. GeoConsult conducted a flow data analysis of period 1985 to 2023.
Next is something which is in your favor. You should have taken us to that first.
Which
The
your
next sentence.
No hydrological assessment was conducted for potential reservoir induced seismicity.
Yes.
That was not conducted.
That's right. When that question was put, you should have taken us directly to that, is it not? Rather than
I get your relation to that, your lordship,
beating
but
around the
my
bush.
contention
Yes.
still stands along with
Carry
this.
on, carry on. Yes.
So, at last, your lordship, even the EIA says so, that there was no seismicity survey conducted. That was my contention. Biogas was avoided and seismicity was also avoided. Now, the second issue deals with the violation of fundamental rights, a very important topic for the court to observe. Firstly, which fundamental rights have been violated? We can say from the very fact Article 21 has been violated. There were indigenous communities, more than 58 villages were living there. Now, what happened without any consultation? They had been thrown out of their home. And as per the judgment decided by the Honorable Supreme Court in Oligatilis, we know that very fact that life is not a mere existence, but a life with dignity. So these people were displaced without consultation. And displacement is a very important subject in Forest Right Act. When you remove someone from that particular forest area, the consultation is a mandatory provision along FRA Act also mandates it. Further on, Your Lordship, in case of there is a case called Subhash Kumar of the state of UP, in which the Supreme Court held that right to life also includes their access to clean water as well as clean air, Your Lordship. If you look into the very clear, if you look into the paragraph number 26, 27, you can see what it resulted with. The construction of dam resulted in. Your Lordship, I will take 2 minutes to complete this issue.
2 minutes.
2 minutes, sharp 2 minutes, Your Lordship.
Yes.
So, what it had resulted in, the increase in number of mercury in water content. People were dying because of the construction of dam. There was landslide happening. There were fishes which got affected. These people are indigenous people, Your Lordship. When we speak about 21, we are also going to the Article 14, which is also violated. Element is the very opposite of equality. Now, what happened here? There was a national language imposition on an indigenous committee which does not know to read or write their language, except their language, according to annexes. Now, the point is, when the people dissented or had a dissenting opinion towards the government, the state had arrested them. And further on, Your Lordship, they had recorded it as unanimity. So this very clearly shows Article 14 is being violated. And now further on, Your Lordship, along with that, Article 25 is violated. A religious freedom is also getting violated. How I say? There were 3 sacred sites for this particular indigenous community. This people respondent come inside of this particular thing and inspect it, saying that it is an heritageable survey. But later what happens is, they found that these are the mineral deposit and started their drilling there. Now, their sacred sites of an indigenous community is not like a popular religion we find here.
Not better. It is better not to go to Article 25. Then you will have to establish that this is part of it is a part of their essential religious practice.
Indeed.
And they form a religious denomination.
Indeed.
Concentrate on focus
Indeed,
on
Your
14 and
Lordship.
21.
My only
Yes.
contention was
Yes.
that is a sacred site for them, which was also distorted. Now, another thing is, Your Lordship, Article 19 clause 1 clause G was also violated because this women are involved in forest activities. Such includes fishing. A community was dependent wholly on fishing, Your Lordship. And this was also violated. They were thrown out of their homes. And along with this, Your Lordship, I would like to conclude by saying that the TEK, traditional ecological knowledge, was also abrupted by the respondent, Your Lordship. If Your Lordships are satisfied with the facts and arguments presented, the co-counsel will be dealing with the 3rd and 4th issue. Much obliged, Your Lordship.
Much obliged. Council seeks permission to address the bench collectively as Your Lordships. Much obliged. May it please this Honorable Court. Issue 3 is whether attributing liability to the parent entity violates the bilateral investment treaty and whether the union unconstitutionally overrode the state jurisdiction. Your Lordship, in order to deal with issue 3, the counsel for petitioner would like to divide it into 4 limbs and deal with it. The first limb being whether to decide the absolute liability of Megacorp Industries Private Limited on the Aranyagram deaths. And second being piercing of the corporate veil to reach the Megacorp Global SA, which is the parent entity of Megacorp Industries Private Limited. And the third being whether such piercing of corporate veil amounts to indirect expropriation under the bilateral investment treaty signed between Aurora and Zenith, and whether it is exposing Aurora to a $2.8 billion liability. And the final limb being union's use of entry 54 of list 1 along with article 253 to override Verdantia's concurrent power over forest is unconstitutional or not. If Your Lordships are well versed with. Much obliged, Your Lordship. So the very first submission the council would like to make with limb 1 for issue 3 is that, Your Lordship, hydromine nexus project inherently is a hazardous activity and the doctrine of absolute liability should be held upon Megacorp Industries Private Limited for the Aranyagram disasters. Your Lordship, the Council is pleased to establish how it is inherently hazardous. The Council would like to invite Your Lordship's attention to Annexure A, the Environmental Impact Assessment Report, Clause 2.1, where it describes the project thoroughly as a concrete gravity dam of 142 meters height, 410 square kilometers reservoir, 2000 megawatt hydroelectric facility, rare earth mining of 620 kilometers, and most importantly, a diversion of 782 hectares of forest land. Your Lordship, all of these are executed in Verdansia Highlands, which is characterized by a geological instability, which is again mentioned in Annexure C, Clause 6, Clause 6 specifically, Your Lordship. So thus the respondents, knowingly that this Verdansia highlights and this particular area is a geographically geologically unstable area, they have hosted blasting and excavation in an environmentally and geologically vulnerable region, Your Lordship, and which is why this is to be considered as inherently hazardous activity. In order to elaborate that, Your Lordship, the Council would like to state that in MC Mehta versus Union of India, in compendium flag number 1, it is given, Your Lordship. The Council is inviting your attention. Enterprise engaged in a hazardous or inherently dangerous activity owes an absolute and non-deligible duty to ensure that no harm results to any person. Your Lordship, in order to fully understand the inherent nature of the hazardous activity, it is also important to take into consideration the hydromine nexus project as a
A treaty that is entered between two countries, is it not? And the parent entity being Zenith.
Indeed, Your
And
Lordship.
then how do you fix the liability in the light of the conditions or the clauses in the treaty?
Okay. Your Lordship, in this particular matter, we are contending that Megacorp Industries, the industry which was working in India, should be held absolutely liable. And coming to the point, please to answer to the question of Your Lordship, where the point of corporate veil piercing is taken into account. Lordship, the doctrine of separate corporate personality established in Solomon versus Solomon is not absolute as in our knowledge. And flag number 7 of the compendium, Your Lordship, the Council would like to invite your attention to the case of Balwant Rai Saluja versus Air India Limited. This is a case of 2014 where it is held that courts may disregard separate legal personality whenever justice, public policy or statutory objective demanded. Your Lordship, in this particular matter where Aranyagram landslide and the deaths occurred, there has been justice in question, public policy in question, and statutory objectives of the Aurora legislations are also in question. In order to prove this, Your Lordship, when the landslide occurred and when the environmental liability arose, it was not the petition, it was not it was not Aurora, Your Lordship, but rather it was Megacorp Global SA that didn't stay separate from this. What happened? They invoked the bilateral investment treaty. They have sent a notice of dispute and they threatened our nation with ICSID arbitration, Your Lordship. So
Now, how
this,
do you wriggle out of the clauses in the bilateral treaty? How do you
Your Lordship,
can the court turn a blind eye towards the treaty?
indeed, Your Lordship, much pleased to answer that question, which is actually the third limb of the issue, where the Council would like to contend that there is no indirect expropriation or direct expropriation, which is dealt by the Annexure E itself, Your Lordship, which is the bilateral investment treaty. The Council would like to invite your attention to Annexure E. In Article 5, expropriation and compensation part is dealt. Your Lordship, expropriation is stated as a state measure that substantially deprives an investor without satisfying the treaty requirements of legality, public purpose, due process and compensation. But the very Article 5 itself in 5 clause 4, it has carved out the exceptions, Your Lordship. The exception includes legitimate public welfare objectives, including environmental protection, Your Lordship. This exception...
See, everything activities done after obtaining permission from the statutory authorities and all.
Indeed, Your Lordship.
How can you resort to these provisions in such a situation? There was no negligence. You cannot attribute negligence or anything. Only that as a consequence of this activity, this landslide occurred.
Indeed, Your Lordship.
Everything done after obtaining all statutory permissions and all.
Indeed, Your
And
Lordship.
can you then go to this treaty provisions and say that there is absolute liability and all?
Your Lordship, it was the Senate parent, it was Megacorp Global SA itself who invoked the bilateral investment treaty, claiming that the nation will have to pay a 2.8 billion US dollar if we are holding the project, or if we are holding them liable for what happened. And in the other first and second limbs, the council contended how it is so the two entities are interconnected and how the corporate veil has to be lifted. Your Lordship, in order to answer your question, the council would also like to redirect your Lordship's attention to further articles in the bilateral investment treaty itself. Article 12 specifically, which is most importantly, it gives sovereign right to Aurora, which is our nation, to regulate environmental protection and sustainable
Of
development.
course, only on those exceptional circumstances you may able to lift the corporate wheel and claim,
Indeed, your
etc.
Lordship.
But when everything done legally according to the developer,
Your Lordship, which
can
is
you
why-
go to exception?
Indeed, Your Lordship.
And
Which is why the Council for Petitioners would like to contend that such a unfortunate incident occurred, and now it is the need of an hour to lift the corporate veil and blame them, because Megacorp Global SA is not standing in isolation. It has assets in our nation. It is operating and it is economically interested in our nation. It has invested. So now, when such a large scale incident has occurred, we, the Council for Petitioners, believe it is important for the court to lift the corporate veil and sue them, so that it will stand as an enforceable right with the petitioners in order to stop their further activities. Your Lordship, there is polluters pay principle as per Vellore Citizens case.
let
So,
them pay. That's all. If they are resorting to polluter pay principle, it can be in terms of money.
Your Lordship, which was not the contention of the Council for Petitioner. The Council for Petitioner was trying to say that the exceptions are invoked by the petitioners right now, because they have invoked the bilateral investment treaty in the first hand, and now it is needed to prove that this is not an indirect expropriation. Rather, this is legally sanctioned as per the bilateral investment treaty itself, which is signed by both the countries. There are clear exceptions. I hope I've answered your
Yes,
question,
very
Your Lordship. Your Lordship, further, if Your Lordships are clear with the three limbs, Council would like to move to the fourth limb. Your Lordship, the fourth limb states, Union's invocation of Entry 54 List 1, read with Article 253, overrides the Verdantia's concurrent power over forest. Your Lordship, Entry 54 of List 1, Union List, give Parliament the power to regulate over mines and mineral developments. And Article 253 of the Constitution of Aurora permits the Parliament to make laws to implement treaty. But Your Lordship, here, in order to make hydromine nexus project possible, the Union has invoked Entry 54 under the veil of colorable legislation. The petitioner would like to contend, Your Lordship, because hydromine nexus project is far more than a mining project. Entry 54 is solely resolved for mining, and hydromine nexus project, as established in the previous contentions itself, Your Lordship will be aware, it's more than a mining project, and it affects forest.
What is the basis of your submission? Mining is defined under the Mines and Minerals Development and
Indeed,
Regulation
Your
Act.
Lordship.
And if it falls out of the definition of mining, then you will have to establish that.
Indeed, Your
With
Lordship.
reference to the definition. Is it
Indeed, Your Lordship. Moving further to
Yes,
that
yes.
contention. Your Lordship, which is why the Council would like to contend that this particular project involves the matters of forest, wildlife, indigenous communities, rivers, and rehabilitation. And hence, Entry 54 is absorbing every other concurrent list entries over which the state of Verdantia has power on. So, Your Lordship, it was after 42nd Amendment of the Constitution in the concurrent list entry 74A and 74B, 74A for forest and 17, pardon the negligence, Your Lordship, entry 17A and 17B, 17A for forest and 17B for protection of wild animals and birds were induced. So, and we have the ruling of landmark SR Bombay versus Union of India, where we have emphasized on the federal structure of our governance and constitution, and this federalism is a part of the basic structure of the constitution itself. So, which is why, Your Lordship, by the action of Union invoking Entry 54 of List 1, along with Article 250 to implement such a treaty, it is taking away or absorbing all the concurrent powers which is vested in the state of Verdantia, Your Lordship. The Council acknowledged the fact that when the law come into conflict, the repugnancy also come into picture, which is why the Council would like to address that the petitioners have no problem in union taking decision or passing laws which is based on minerals and mine regulation. But here they are using it as a shadow or a veil to make sure that hydromine nexus project is happening, which is exactly the problem of petitioners, your lordship. And which is why the petitioners contend that union's invocation of the entry 54 under list 1 is unconstitutional over the concurrent powers of Verdantia, your lordship.
Now, the contention that the respondent would raise is that this is in the national interest
Indeed.
and it is a policy decision of the government.
Indeed.
Now, how far there can be judicial review of a policy decision taken by the government in national interest? Can, in exercise of the power under Article 32, the Supreme Court set aside all those decisions and hold that this is not in national interest? Even if it is in national interest, then this project cannot go on. Does the Supreme Court have such power under Article 32?
Indeed, your lordship, the petitioners contend that the Supreme Court has to take into matter these conflicting interests of union and state, because here the lives of the tribes are weighed against a far-reaching and anticipated climate achievement that are being made by the union. So in that particular matter, if the intervention of the Supreme Court is not coming into picture, the Aranya Grams incidents will occur more, and that will be at a point where we can't fight it. As rightly pointed out by your lordship to my council, we will be in a state where we are too late to invoke it, your lordship. If your councils are satisfied with issue 3, council would like to move. Pardon, if your lordship, sir.
If there was no landslide,
Indeed.
whether you would have approached the court?
Indeed, your
Only
lordship.
because you approached the court only because of landslide.
Indeed not, your lordship. Your lordship, for that particular question, the council would like to contend that along with the landslide, which is why, according to Professor Vega's report, Annexure C, in that it is saying.
I'm only asking some facts.
Indeed.
If there was no landslide, whether you would have approached the court?
Indeed, your lordship, the council for petitioners contend that landslide has been the immediate cause for the petitioners to approach this honorable court, but soon or near, the council for petitioners would have approached this honorable bench, because there have been methyl mercury poisons happening in the Verdantia river, which has already started affecting by giving neurological disease to the children and even pregnant women. The methyl mercury content is above the WHO limit, which is permitted for pregnant women and children, and the Aurora tiger habitats are at the brink of an extinction. So this landslide, we accept that it has been the immediate cause of approaching this honorable bench, but sooner or nearer, once these things have been coming into picture, the council for petitioners would have definitely approached this bench seeking relief, your lordships.
So even
See-
if there was no landslide, you would have approached.
Indeed, your lordship.
See, to approach that question in a different perspective. See, landslide, what was the effect of landslide? Lives lost,
Indeed.
environment devastated.
Indeed, your lordship.
But see, even without that, it's a dam. When water is collected, natural consequence should be damage to the environment.
Acknowledging your question, your lordship,
You
which is why the council would
you
like to
did not
condemn
take up
that.
that matter. Only when this incident occurred, you came forward.
Indeed,
So,
your lordship.
Maybe he doubts. My
Which is why
brother
the petition-
doubts your bona fides.
Indeed, your lordship, which is why the council for petitioners humbly contended that the immediate cause for approaching this bench has been the landslide itself, but that has not been the reason alone. Because when taken into consideration the hydromine nexus project itself, we should not limit, the council believe that the bench should not respectfully limit itself to the dam construction, where the mineral extraction and because it's hydromine nexus project, it's a combined project, and the rare earth mineral extraction is more volatile in nature or more dangerous in nature than that. So which will obviously be a matter of interest of the petitioners and as well as your lordships.
Representing indigenous people there.
Indeed.
So they know better than this scientist even
Indeed.
what would be the consequence of this kind of an activity.
Indeed.
Because they know naturally
Indeed, your lordship.
what would be the impact of the
Indeed.
human activities,
Indeed,
which is
your
not advisable or protective of the nature there, habitat there.
Indeed,
So
your lordship.
that was not taken up till this incident occurred.
Your
That's-
Lordship, positively agreeing to the statement of Your Lordship, the indigenous people have much far knowledge than any of us or the experts according to their highlands. And which is why my co-counsel has rightly pointed out how their traditional ecological knowledge itself has been exploited by the respondents in order to make this project into a success. And which is why at this point, the EcoGuard Islands and all the petitioners, we believe that this is the high time to take the intervention of the court into this matter, Your Lordship. If Your Lordships are satisfied, Council would like to move to issue 4. Your Lordship, issue 4 is whether climate justice and intergenerational equity constitute fundamental rights under Article 21. Your Lordship, as mentioned by my co-counsel itself, the council would like to cite the case of Subhash Kumar versus State of Bihar, in which it was held that right to life under Article 21 includes right to enjoy pollution-free water and air, which is directly breached by this project, Your Lordship. Lordship, Hydromine Nexus project claims is to be a green labeled infrastructure and a top tier 1 project. But Your Lordships, they also claim that they avoid 8.2 million tons of CO2 once after coming into picture. But Your Lordship, these are anticipated results of the project, Your Lordship, because moving further, Your Lordship, but the question is whether the constitutional burden of proving that this project is genuinely advancing the climate protection is satisfied or not. And the council would like to condemn that it is not, Your Lordship. There is huge ecological loss that will happen due to the project's execution, which is mentioned in Annexure C, Your Lordship. The habitat of Aurora tiger, as the council have mentioned earlier, will come into extinction. The methyl mercury poisoning happening, and the discharge of effluents, and recently the landslide happened. So the question before this honorable bench is whether to weigh against the climate change that is anticipated and a irreversible ecological destruction that has already started in our nation, Your Lordship. And moving further, Your Lordship, the government, the council for petitioner also would like to bring into picture.
The government would rely on sustainable development to say that the long-term effects, the long-term profits that are generated will offset the temporary losses or the. So how do you handle the question of sustainable development? Because the nation has to develop,
Indeed.
and for that we need mines, dams.
Indeed,
And
Your
that,
Lordship.
in a way, we have to. There may be deforestation.
Indeed.
There may be some displacement of some persons.
Indeed.
But for that reason alone, can we hold development the process to halt?
With much respect, the council would like to answer to your question, Your Lordship. This Verdantria highlands where all these activities are being taken place is situated in ERR, which is a UNESCO World Heritage Site, Your Lordship. Of course, sustainable development brings into picture, like Your Lordship has rightly pointed out, some deforestation, some activities that are happening, or some maybe to an extent we might be able to suffer some landslides or something. But the point here the council is trying to prove is that this particular project becomes which is claiming to become the net greenhouse gas positive after 20 years of coming into existence, which is no scientific evidence is both, but the respondents are claiming, Your Lordship. But meantime, we should look at what and all it is destroying, Your Lordship. 410 square kilometers of tropical rainforest, which comes under this UNESCO World Heritage Site, Your Lordship. And also a detachable, also the ecological balance of ERR, and it push Aurora tiger, which is to extension, Your Lordship. So this project can't be done at the cost of the destruction of an irreplaceable ecosystem, which is the contention of your council, Your Lordship. And yes, Your Lordship, because it was and this is how it is breaching Article 21 and right to life, Your Lordship. The council would like to further talks about intergenerational equity, which is also should be taken into picture. Council would take 1 minute to conclude the issue, Your Lordship. So in MK Ranjit Singh and others versus Union of India, Your Lordship, it was recognized that climate change as a constitutional concern affecting not merely the present generation, but those who will inherit the consequences of today's environmental decision. Your Lordship, with much respect to the statement that Your Lordship have made, exactly, sustainable development is again interlinked with intergenerational equity, which has to be taken into paramount importance by this honorable bench, we plea. In that matter, The submissions for fourth issue is done, Your Lordship. If Your Lordships are satisfied, counsel for petitioner will move to the prayer, Your Lordship. Much obliged. In the light of the facts stated, issues raised, authorities cited, and arguments advanced, it is most humbly prayed before this honorable court that it may be graciously pleased to declare the environmental clearance dated 2012-2022 as constitutionally invalid, void ab initio, and liable to be quashed for being granted in violation of EIA notification 2006 and Article 14 and 21 of the Constitution. Declare that the hydromine nexus project violates the fundamental rights of indigenous communities under Article 14, 19, and 21, and that the Gram Sabha consent dated 14/6/2022 is void ab initio for having been fraudulently obtained. Declare that Megacorp Global SA is jointly and severably liable for the acts of its subsidiary, and that the union's invocation of entry 54 of List 1 and Article 253 to override state jurisdiction is unconstitutional. Declare that the climate justice and intergenerational equity constitute enforceable fundamental rights under Article 21, and that the state has violated the public trust doctrine by authorizing the permanent destruction of ecological resources, and or pass any other order or relief that this honorable court may deem fit in the interest of justice, intergenerational equity, and the rule of law. All submissions are most humbly submitted, counsel for the petitioners. It was such an honor to argue before this honorable bench.
The council seeks permission to approve the time. A very good afternoon to the honorable bench. May it please this honorable court, this is the council appearing on behalf of the respondents, that is the Attorney General appearing by means of Article 76, and my co-counsel, the Solicitor General, appearing on behalf of the Union of Aurora. However, we'll also be collectively representing the interest of the other respondents in this party as well, namely the respondent number 2, the NERA or the National Environmental Regulatory Authority, respondent number 3, the State Government of Verdantia, and respondent number 4, Megacorp Industries. My lords, before moving on to the issues itself, the council would like to deal with the issue of maintainability, if your lords permit.
Yes.
Yes, much obliged, my lords. My lords,
Had it been an actual court, we would not have permitted you to argue.
yes, my lords. We would,
For Megacorp at least.
yes, your lords.
The other entities, of course. Yes.
Your lordships, here in this present matter,
Yes.
it is to be noted that there are other bodies that they could have approached as well. The first one being the NGT. But the statement which was made by the petitioners in this present matter was, we had already approached the NGT, but they had ruled it in favor of the respondents, which is completely a factually inaccurate claim, your lordships. Here in this present matter, as it is clearly recorded in the proposition itself, it was not the petitioners who had approached the National Green Tribunal in the first place, but it was the NGT who had felt that there might have been certain lacunas in the environmental impact assessment report. And then it went on to review the environmental impact assessment by individually commissioning a Professor Vega Delta's report, your lordships. And then further, the other, your lordships, NGT specifically deals with these type of scientific issues under section 16. They could have gone for an appeal of the environmental impact assessment, but they did not go ahead with the specific statutory remedy. And next, your lordship, they go on to the High Court. And even in the High Court, it has been dismissed.
You mean to say that government has to be distrusted? When the government is there, government and authorities according sanction for this, they can simply believe you, government. And it is for the benefit of the people. Only this incident occurred. People realized that government did not even applied mind.
Certainly, your lordship.
And
Certainly, your lordship, but here the issue is that they are claiming that we would have approached it prior itself, and we have satisfied all the remedies itself. But whereas they have not approached the only remedy which they have tried to approach is the High Court, your lordships. And even at the High Court, it was ruled once again in the favor of the respondent, stating that the environmental impact assessment is not justiciable. And then further, your lordships, even under the Forest Rights Act itself, we have a provision under section 6 to appeal against this specific Gram Sabha resolution. Even that has not been approached in this present matter. They have directly approached Article 32 without even invoking the appellate jurisdiction against the High Court judgment as well. And further, your lordships, even if we set aside all of this, it is also to be noted that one of the petitioner parties in this present matter is Future Generations Trust. Your lordships, if we look at Future Generations Trust itself, it does not withstand scrutiny because a writ petition under Article 32 requires an applicant to demonstrate the violation of a legally cognizable and presently enforceable fundamental right.
We need not go into the technicalities. See, even letters are treated as public interest litigations. Now we have
Yes, your
we
lordship.
have traveled a long way from MC Mehta onwards.
Yes, your lordship. Certainly.
Now the very fact, the mere fact that they had not gone to the tribunal but the fundamental rights of certain class of persons, class of deprived persons are violated. Their fundamental rights are infringed. It is brought before the Supreme Court.
Yes, Your
and it's for the Supreme Court to decide. It behoves the fact that the National Green Tribunal has held otherwise, or the High Court has taken a different view. So,
Your Lordships, if your Lordships are on the page to admit this into hearing,
Yes.
the Council will be more than happy to argue. But the Council still has a contention regards to judicial review when it comes to policy decisions, Your Lordships.
yes.
Your Lordships, let us take the Lafarge mining case itself. The Lafarge mining case clearly lays down certain standards. It talks about when judicial review can happen when it comes to policy decisions or clearances of the same nature. Your Lordships, it talks about in the circumstances barring exceptions. Your Lordships, it has been marked in the compendium, Your Lordships. Your Lordships, we really apologize. We had prepared 3 copies, Your Lordships, but one of them was intended to be for the opposition council. And we did not find time to mark the specific. Your Lordships, in the Lafarge mining case as well, which is 2011 7 SEC 338. The legislative policy underlying the law. The GeoConsult has definitely followed the terms of reference. The legislative policy underlying the law. The GeoConsult has definitely followed the terms of reference in this present matter. And then finally, is the decision consistent with the principles of sustainable development in the sense that the decision maker has taken into account the said principle? Your Lordship, the entire basis for this project is the NDC, which was based on this process of sustainable
I have
development.
an argument that they were from the stage of preparation of the report itself, things were suppressed. There was an attempt to commit fraud, and it was based on such suppression that the environmental clearance was granted.
Yes,
and
sir.
they have also got a case that the consultation was not proper, and there was no informed consent from the persons who were affected by this.
Your Lordships, even in this Lafarge paragraph as well, the next paragraph would state that the doctrine of margin appreciation has to be taken in favor of the respondents. But setting aside all that, we have the Narmada Bachao cases as well, which favor the respondents. But we'll go on to the merits in this present matter, Your Lordship. The suppression of these seismic factors, which the petitioners are contending. Your Lordships, it is very pertinent to note that they have not been suppressed. They have been acknowledged. But it has been acknowledged that they are outside the terms of reference. Your Lordships, let us see what is the process for this terms of reference itself. The terms of reference does not come from a vacuum. The project proponent prepares a Form 1 and they submit this Form 1 to the regulatory authorities. And then the regulatory authorities take a look at this Form 1 and then they formulate a TOR. And this TOR goes through multiple levels of scrutiny by expert committees, which is the EAC or the SCAC, which is made up of nearly 15 experts in this specific field, Your Lordships. And then even after this, the draft EIA report goes through SPCB, which is the State Pollution Control Board, or the UTPCC, depending on the territory. Even after going through all of these scrutiny levels, they have still relied on the fact that here seismic assessment might not be necessary. And then further, Your Lordships, let us set aside all of this. The sole petition that they've been relying on is the report by Professor Vega. Your Lordships, they would rather rely on a single report which has not been taken into consideration by the NGT itself, because it was the NGT which independently commissioned this. But then the final ruling was in favor of the respondents. They stated that the dam construction can continue and the mining has to be partially continued because certain safeguards has to be installed. And they're relying on such a report and they're completely going against all of these expert committee reports, Your Lordships, in this present matter.
You're putting forth all these arguments in the face of a calamity that has occurred, which has resulted in loss of life. 20 persons lost their own life, and now you can't go back to the NGT and say everything was verified by the NGT, the expert bodies. But then how could this calamity have occurred?
Your Lordships, regarding to the landslide, Your Lordships.
Yes.
Your Lordships, the landslide happened due to an unfortunate accident. We do apologize for it. We plead liability for the same. But however, but it has to be limited to the 5 crore ex gratia payment that we have offered in this present matter, Your Lordships. But rather stating that the entire project itself should be halted is a completely untenable claim, Your Lordships. That is exactly that.
The landslide occurred after commissioning of the project,
Yes,
and a few years after, this contention could have been accepted. This project work is going on only. Even at that initial stage, it occurred. What would be the havoc that may occur after the completion of the project if it happened at this stage? What would be the future of that environment there?
Your Lordships, we have two possible scenarios. One where the project itself is adversarial to the environment, and one where the project is not adversarial to the environment, but unfortunately due to an accident, a specific accident, where because of the absence of safety protocols in that specific incident as clearly recorded in the proposition itself.
Why do you say that the project is not adversarial to the environment?
Your Lordships,
Now mercury is seeping into the water. Now
The council- if the
the
council
Forest will
could
be submerged.
it will be at least 420 square kilometers will be submerged, and there will be a rippling effect, cascading effect in the nearby environment. Now the tiger population, the dolphins.
Your Lordships,
Yes,
if the council could deal with all of these
yes,
in a more brief manner.
yes.
Your Lordships, now coming to the first of all, the GHG assessment. Your Lordships, it is very important to note.
Yes.
Let us take a look at what was initially given by us. It clearly states that we will achieve parity by year 18. And after year 18, it will be a net emitter, which means that it will not emit and rather it will absorb all of the greenhouse gases. And then further, it avoids 8.2 million tons of CO2e annually for the remainder of its half century. But now let us look at the claim which is based by Professor Vega in this present report. In C.5.1 of the annexures, the proposed 410 square kilometer reservoir will inundate approximately 31.2 million tons of the above ground mass biomass carbon. However, your Lordships, it is very pertinent to know. What is this 410 square kilometers? Your Lordships, it has been clearly recorded in Annexure A itself that 410 square kilometer is the maximum capacity of the reservoir.
But then
It is not the usual capacity.
That 410 square kilometers is forest.
Your Lordships-
It is thick vegetation, is it not?
Yes, your Lordships.
Yes.
But that the 410 square kilometer area will be covered only when it is functioning in its full capacity. It is not the usual full capacity, your Lordships. Therefore, the effect will be mitigated to an extent. And even so, it is also pertinent to be noted that this is not a singular project. It is a hydro mine nexus project. There is also a mining process which is taking place, and the entire idea of that mining to be taking place in the very first place is to increase the production of the EVs or the electric vehicles, which has been clearly recorded as well. We project a 60% increase in production of electric vehicles, your Lordship. And the entire purpose of production of electric vehicles is to cut down these greenhouse gas emissions. But however, these factors have not been taken into account by Professor Vega's report. So these are the contents, your Lordship. This comes with the GHG emissions. Now, your Lordship, moving on to the next submission, which deals with the methyl mercury. Your Lordships, if we clearly take a look at the annexes itself, the petitioners claim that we are master manipulators, that accusations have flown around this court. But however, they have conveniently left down certain parts within the annexes itself. As recorded in Annexure A itself, the hydromine nexus features rigorous engineering safeguards, namely impermeable lined tailing ponds, your Lordships. These impermeable tailing line ponds will essentially store down any sort of emission that might happen from these reservoir plants or so and so, in order to make sure that such methyl mercury deposition will not happen in the first place itself. And your Lordships, even let us set that aside. If this is not enough, we also have an EMP which we have submitted in the first annexure itself. In the EMP, it clearly records in 8.7 real-time pollution monitoring, which includes online sensors at 12 discharge points with public data portal. Therefore, we have clearly taken measures to mitigate this claim, your Lordships. Then, what might be the possible cause of this methyl mercury deposition, your Lordships? If we were to talk on a little bit more scientific basis, your Lordships, methyl mercury deposition need not happen only because of these rare earth mining extracts, your Lordships. Methyl mercury poisoning happens in a lot of places because of industries as well. Because when industries produce coal emissions, those coal emissions have the power to cascade.
All those activities are taking in industrial areas. Now we are talking about a pristine, untouched vegetation and a population which is entirely dependent on that. So the consideration is entirely different. Now Ganga is getting polluted because of all the industries. True. Now this has been happening, but then you are entering a virgin forest and starting an activity which is detrimental to the environment.
Certainly, your Lordships, that is exactly why the council decided to move on a scientific basis, because scientific studies, your Lordships could commission an independent body to review this as well. But scientific studies clearly state that these carbon emissions have the power to travel a much larger distance than what this ERR covers itself, your Lordships. Therefore, the very fact that this was the causation for the methyl mercury sedimentation has not been put forth before this court by the petitioners, your Lordships. And now coming to the...
Are you ready to extract, remove these minerals to an industrial area and process at that place so that this pollution would be...
Your Lordships, the very...
Are you ready to take away these minerals to an industrial area and process
Your
so
Lordships,
that you could avoid polluting this?
Your Lordships, here in this present matter, the only reason why the areas within this ERR, namely the Kalpavriksha Konda or the Tirtha, all of those regions have been chosen in this present matter is because they contain certain rare earth minerals which are abundantly available in this present matter, your Lordships. And even in the Lafarge case as well, they had pleaded the land to the mining corporation because it was completely left unused in that present matter, your lordships. And here it is of no use being under the land in this present matter. However, your lordships, it is very difficult to find these specific rare earth minerals in outside areas, your lordships.
You can collect from here and take it to an industrial area.
Your
and
lordships,
process it.
your lordships, that would lead to even more possibilities of discharge, your lordships. Extraction of all of those minerals and then transporting it would require an even further transportation system, a pipeline separately for it, which would even lead to further possibilities of discharge.
Will not extraction violate the rights of the forest dwellers under the Forest Dwellers Act?
Your lordships, all of that is subjected to national importance, your lordships. The Odisha Mining Corporation case as well has recognized that the state has the authority to extract minerals from specific land sites, your lordships. However, it has to go through proper consultation procedures, was what was laid down in the Odisha mining case as well. Therefore, there is no question as to whether the state has the right over the minerals in the specific matter, your lordships.
Or can that right override the fundamental rights that is guaranteed to citizens?
Your lordships, fundamental rights on the ground of
Article 21, right to life. Right to life encompasses everything.
Your lordships, here on prima facie as well, and even in a detailed manner, there is no violation of Article 21 because the EMP clearly states down multiple rehabilitation procedures that the state and the megacorp together is willing to give. We have a separate biodiversity fund. We have separate 1% of revenue allocation, and more and more rehabilitation. Everything is provided under the EMP plan itself, your lordships.
Can you say that these tribal people are displaced to some other location from their natural habitat? Does
pluck
not
them from their
involve
habitat.
any
Your
denial of
lordships,
natural
it is
jurisdiction?
also to be noted that out of the population of nearly 10,000 people, a maximum of 20 to 25% will be the only persons who are displaced because there's a total of around 2,400 people who are being displaced. But the remaining 7,500 will still have the access to this land. Your lordship,
That is one aspect of the matter. Tigers there.
yes, your lordships, coming to the tigers. Yes, your lordships, coming to the Aurora tiger. The species was formally classified under the IUCN Red List only in 2023, which is clearly recorded in the annexures itself. However, the environmental clearance was granted in 2022. And further, your lordships, paragraph 8.7 of the EMP in Annexure A, which the petitioners have conveniently forgotten, clearly reads that Megacorp has already built exhaustive safeguards to satisfy the species' best interest, as laid down in the cases which they cited as well, which was the MK Ranjit Singh versus Union of India case, where we have clearly mentioned in the EMP, including the permanent retention of 15-meter habitat buffer zones and the construction of wildlife underpasses at 4 critical roads crossings to preserve natural migratory pathways. This we have guaranteed within our EMP itself, your lordships. And let us leave all of this aside and let us look at the case which they cited itself.
You meddle with their natural habitat, construct underpasses like human beings. You can't expect the tiger to find out the underpasses, wait for crossings and go to the other place. It is their natural habitat that you're interfering with, and you can't rely on the aspect that it was way back in 2022 you got the clearance. Tigers does not they want to roam around.
Yes, sir.
It is tiger territory, and therefore you can't say no. We have constructed underpasses. Let them go through the underpasses.
Certainly, your lordships.
Yes.
For that contention, the council like to rely upon the same case that the petitioners have cited in this present matter, which is the MK Ranjit Singh.
Place some signboards for them.
Based on signboards.
Your lordships, let us take a look at what happened in that case. In that case, your lordships, the petition was seeking protection of the critically endangered Great Indian Bustard, which is very similar to what is happening here, from overhead transmission lines. And in that specific matter, your lordships, the court declined to impose a blanket undergrounding requirement, instead directing an expert committee to balance species conservation against renewable energy imperatives. That is exactly what we're trying to do here, your lordships. If your lordships want to impose certain safeguards and want to constitute an expert committee in order to ensure that these measures will be mitigated, the council for the respondents would be more than happy to accept the same, your lordships. But rather halting this entire project itself in its entirety. Yes.
What to do when it is pitted against the directive principles of public policy 48A and then the fundamental duties that is cast upon citizens to protect the environment? And can the state take a completely divergent, a totally different stand and say when it comes to national interest or rather development, we'll forego all this? But what is enshrined in the directive principles is what this nation intends to achieve over a period of time. And there will be a setback if projects like this is allowed, is it not?
Your Lordships, this question comes into play
Yes.
when we are dealing with commercial projects
Yes.
that are of high public importance. Even in that cases, they'll try to balance out the ecological effects and the national development. But here in this matter, it is very pertinent to note that this is not a commercial project. This is rather green infrastructure. Your Lordships, apart from having commercial interest on its own, the entire objective of this project in the very first place is to have green effects. Your Lordships, as of right now, we are importing rare earth minerals from other countries. Nearly 92% of our imports come from other countries. However, because of this, we'll be able to extract rare earth minerals from our very own country. And then we'll be able to completely switch on to, our government is shifting towards ethanol-based cars, Your Lordships. And with this, we'll be able to shift from ethanol-based cars to EVs in this present matter. And then further, Your Lordship, the greenhouse gas emissions, they are not neutralizing the effect, but rather they're absorbing the greenhouse gas effects, which are present in this present matter, which are present as of right now, Your Lordships. So rather than compromising on the environment, it is making sure that the future generations have access to a very better environment than what we are having today.
Are you not bound by, now you being the Attorney General, can you say that the state is not bound by the treaties and the international conventions which require the state to protect the environment, which requires the state to protect the environment under Article 253, 51C?
Yes, sir.
Yeah? The state is bound to abide by the conventions and the treaties which the Paris Commune, the Ramsar Convention.
Yes, Your Lordship.
And how can you forego all that and do something which is
Your Lordships,
yes.
Your Lordships, even if we take a look at the Paris Convention as well,
yes.
the Paris Agreement was the entire basis on which we have drafted this NDCs of 2030 in the very first place, Your Lordships.
Yes.
And even the transparency framework as well, we have clearly signed within the NDC itself that we will annually supplement GHG reports to them, so that if any hazardous activities are taking place within the country, the international monitoring committees will be able to take a look at it. We have clearly subjugated ourselves within the jurisdiction of the international forum,
Yes.
so that they could have a scrutiny over the environmental status within our own country, Your Lordships. Therefore, in no way are we going against the environment, but rather the entire initiative in the very first place is to transition towards a more green energy, and which includes the Hydromine Nexus project as well, Your Lordship. Because the hydropower project was to ensure that hydroelectric power is being generated in this present matter as well. Yes, Your Lordship. Your Lordships, due to the positive time, the Council like to summarize with issue 2 in a very brief manner, Your Lordships. Your Lordships, the issue 2 primarily deals with tribal rights in this present matter, Your Lordships. Your Lordships, if we take a look at tribal rights, we have two primary components, which is the public hearing and getting written responses, Your Lordships, under public consultation in stage 3. Your Lordships, let us further take a look at the exemptions to public consultation. It clearly states in clause 1F of stage 3, all projects or activities concerning national defense and security or involving other strategic considerations as determined by the central government. Your Lordships, here what more of a strategic consideration do we need than an impending 2030 goal in this present matter, Your Lordship?
Can
But
you put forth that as an argument? There has to be a notification bringing it within that framework. And then alone you can seek the exemption. You can't just come to the court and say that we fall within this definition of the meaning and therefore we are exempted and no consultations required. That cannot be. There has to be a positive action from the part of the state granting exemption. Exemption is not something which cannot be asked for.
Certainly, Your Lordships, even if we take a look at one of the most recent
Therefore,
notifications.
we'll go by the, we'll take a view that consultation was required.
Certainly, Your
And
Lordships.
there's no exemption.
Certainly, Your Lordships. Now, coming to the very fact that only 47 people attended the meeting. Your Lordships, let us take a look at the EIA notification itself. Clause 6.2 in Appendix 4, which deals with the procedure, talks about how there shall be no quorum required for attendance for starting the proceedings. Because the mandate itself does not require any sort of minimum quorum, we have made sure that people will attend. And the very fact that the notice was not pasted in regional languages. Your Lordships, it is very pertinent to be noted that the EIA notification does not require any sort of language barriers, any sort of language requirements. But even so, it is also to be noted that there are multiple languages within this ERR itself. So if we actually wanted to make sure that everyone will get the information, we had to make it in a common language, which is the national language in this present matter, Your Lordships. And then further, Your Lordships.
So people living in the dense forest, they are expected to read this newspaper and understand what will be going on.
Your Lordships, Your Lordships, we have to make sure that people will be able to access this specific notice, Your Lordships. And what more of an accessible place could we choose than the district collectorate office? Because this is an ERR. The other places are largely dense forest areas, your lordships, as your lordships itself stated. It is only the district collectorate office which is considerably developed within that
When
territory.
it comes to giving notice, it is dense forest. When it comes to mining, you don't have an issue. You can go there and do the mining.
Your
You can't
lordships,
go there for the purpose of giving notice to the persons who are residing there.
your lordships,
After all, what is the purpose of
that doesn't
notice?
hold water. That won't hold good. Notice is notice. Notice is putting the other person, giving the other person specific information regarding about the matter in which he is expected to appear and give his opinion. That is notice. Notice is something which is not something which is given in an alien language, expecting the other person to be present and give his answer.
your lordships, however, in the EIA notification, there is no specific mention of individual notices being delivered. The notice will be posted and it will be available in the internet where they'll be able to access the environmental
See,
impact assessment report.
as the Supreme Court,
Yes, your lordship.
we cannot be oblivious of the ground reality. So that is it. Of course, probably there may not be a mandate under the notification, but then we are dealing with persons who are not well versed in this language in which the notice was given. Yes.
Your lordships, even if that's the case, your
Yes.
lordships, when coming to these sessions itself, the consultation sessions,
Yes.
one of the most primary concerns of the petitioners was that it was conducted in the national language. But however, your lordships, it was the government which provided interpreters to them. And they had stated that we were denied of independent interpreters. Your lordships, it is very important to be noted that this specific project is a very technical project. So we can't be relying on independent interpreters who might not have the sufficient technical knowledge to explain this project to the present concerned people, your lordships. Therefore, we have made sure that the government interpreters are providing the information regarding the project to the people, your lordships. And then further, even the Gram Sabha resolution as well, your lordships. If we take a look at the recent 2022 notification for the forest conservation rules, which was given in the website as well, your lordships, it was clearly stated that the requirement of Gram Sabha consent is still present.
Okay.
Time is over.
Okay. So you'll have to conclude.
Certainly, your lordships. Just two more cases, your lordships. I'll just cite those two cases. The first, just two submissions, your lordships. I'll be concluding with that.
Yes.
The first one being Chameli Singh versus State of UP, your lordships, in 1996, which has been marked in page number 2 of the compendium, which states, in every acquisition by its compulsory nature for public purpose, the owner may be deprived of the land, the means of his livelihood, because the state exercises its power for eminent domain for public purpose and acquires the land. So long as the exercise of the power is for public purpose, the individual's right of an owner must yield place to the larger public purpose. And coming to the final conclusion, your lordships, why this project must not be halted. Your lordships, the counsels for the petitioner stated the One Shakti judgment from 2024. However, I'm not sure if they're aware of this judgment, but the One Shakti judgment went through multiple further proceedings in 2025 as well. In 2025, there was another proceeding which was the Credai versus One Shakti proceeding, your lordships. In this specific judgment, the One Shakti judgment was recalled completely, and the new judgment held that it will have devastating effects in as much as various completed near completion projects will have to be demolished, which were constructed out of public exchequer to the tune of nearly 20,000 crores. Therefore, it would not be in the public interest to demolish all such projects and permit the money spent from the pocket of public exchequer to go into the dustbin. Therefore, your lordships, we humbly pray before this honorable court to not let a 38,500 crore project of public money to go into the dustbin, your lordships. With that, the council concludes its submissions. The co-council will be proceeding.
Can that principle be applied in a case of perpetual damage?
Your lordships, if my co-counsel could deal with that in more.
He can start from there.
And I'll be dealing with it in the rebuttals as well.
He can start from.
Yes, your lordships.
Your Lordships, this is the Solicitor General appearing on behalf of the Council for Respondents. I will be dealing in depth with issues 3 and 4, Your Lordships. Your Lordships, issue 3 raises two main questions. That is, whether this court can pierce the corporate veil to reach the Zenith parent, not the Aurora subsidiary, and whether the BIT arbitration exposure should influence this court's remedy. Your Lordship, essentially, Megacorp Global and Megacorp Private are two different companies. That is the foundational rule in which we base our contention. This is found in Salomon versus Salomon, where a company is a separate legal person from its owners, and every subsequent case in this area flows from that principle, Your Lordship. Even if we take into account cases in which corporate veil has been pierced, for example, in state of UP versus Renesugar Power, it was held that the veil could be pierced only because of extreme situations such as, let me quote Renusugar Power, Your Lordship. You could find it in page 37, paragraph 2 of the compendium. It is abundantly clear that Renusagar is completely controlled by Hindalco. Renusagar has had at no point of time indicated any independent volition. Your Lordship, heavy reliance has been put on the fact that a subsidiary can only be held as a mere agent when the control is with the parent company. Now let's apply the facts to this case.
Which is the parent company here?
The parent company here is Megacorp Global SA, while the subsidiary is Megacorp Industries Private Limited, Your Lordship. Your Lordship, Megacorp Industries Private Limited is the opposite. It is an Aurora incorporated company. It holds the environment clearance in its own name. It has employed its own workforce. It contracted GeoConsult independently. It operates a 38,500 crore project. It appears before this court as respondent 3. Megacorp Global SA isn't even a respondent in this case, Your Lordship. Renusugar's test, which is no independent existence, is not met in this scenario, Your Lordship. For that reason, the court cannot pierce the corporate veil according to established precedent. Even in Smithstone Knight.
What do you gain by that argument?
Your Lordship, essentially the reason why this whole contention has come here is because of a paragraph from MC Mehta versus Union of India, which states that from absolute liability, the compensation is determined based on the size and magnitude of the company. Obviously, Megacorp, the global one, is in a much higher size. However, it was not responsible for the construction deaths that day, the blasting deaths and the resulting landslide. That was Megacorp Private Limited, and they have offered 5 crore, which is the valuation that they have given. Your Lordship, even in Smithstone Knight versus Birmingham Corporation, which Indian jurisprudence regularly uses, it laid down 6 factors. One of the main factors is the effective control. The holding company must be in constant and effective control, so much so that the daily operations are being dealt and determined by the holding company. That is not physically possible in this case because an Aurora incorporated company has to deal with many rules and regulations and it must follow those. The holding company cannot always have a firm hand in those scenarios.
We'll accept that. This argument is only for the purpose of bringing down the quantum of compensation. That is all. To demonstrate that the 5 crores which you have accepted, going by the size of the subsidiary company, is sufficient compensation. Is it not?
Your Lordship, the reason we put forward this contention is not just to reduce the compensation amount. It is to show that liability, who truly is responsible for the deaths, who truly is responsible for the accident that was caused that day. Your Lordship, now we move on to the treaty, the bilateral investment treaty. And I want to be clear about what we are arguing and what we are not arguing. We are not telling this court to forget about the fundamental rights just because of a commercial number. We are not telling the court to forget about fundamental rights because of a $2.8 billion foreign arbitral award. We are telling this court that the remedy it gives out must be one that actually works, one that endures on the international plane, and one that does not ultimately harm the very people it seeks to protect. Your Lordship, before I move on, I want to deal with the bit itself, articles of the bit. Essentially, our contention is that
on what basis do you present to service the bit, the treaty? You said the corporate veil cannot be pierced.
Yes, Your
This is the treaty is between Zenith and Aurora.
Yes, Your Lordship.
You are a company which is incorporated in Aurora.
Yes, Your Lordship.
How do you rely on bit then?
Your Lordship, the intervener in this particular matter is the Republic of Zenith, and they have contended invoking.
What is the connection of Megacorp Private Limited with Zenith? Or because you say you are a separate legal entity, you
Yes,
rely on Solomon and Solomon.
Yes,
so
Your
you have
Lordship.
got an independent status. Now this treaty is between Aurora and Zenith, and you have nothing to do with whereas your company mentioned. This is an entirely different treaty. How can you rely on clauses in the treaty?
Yes, Your Lordship, but
that is why I earlier asked whether it is only for the purpose of cutting down the compensation, because this runs counter to your earlier argument. Carry on.
Your Lordship, essentially why we bring the BIT into this whole situation is because it is also determining what would happen if the construction of the dam is stopped, if the construction of the hydromine nexus is stopped completely, and that should also be taken into account in this case. That is why we are talking further on this point. They are till some extent independent arguments for each. That's why we have separated them, Your Lordship. Your Lordship, the first question is, does the liability actually arise? If the dam construction is stopped, would the $2.8 billion foreign arbitral award rise? Do I sense a question from Your Lordship?
No, carry on.
Much obliged, Your Lordship. I want to refer to Article 5.4 of the BIT, which can be seen in Annexure E, Your Lordship. Article 5.4 states that non-discriminatory environmental measures do not constitute indirect expropriation unless the effect is manifestly disproportionate. Your lordships, that word manifestly is doing significant work here, as it sets a high bar. When the same protective objective is achievable through regulation, through remediation, through enhanced safeguards and monitored compliance, ultimately halting the project completely, stopping the construction, and then removing the clearance, that would constitute indirect expropriation, your lordship.
Correct.
And-
That is
Yes.
applicable to the contracting parties. Who are the contracting parties in this treaty?
The contracting parties in this treaty are mainly Aurora and Zenith, your lordship, and the investor and the contracting. The investor who made the investment in this scenario would be Megacorp Global, your lordship.
No, earlier you said it's only Megacorp Private Limited.
Yes, your lordship.
Yes.
Essentially, what is happening is that using the BIT, they will be open to a $2.8 billion foreign arbitral award. That foreign arbitral award is because of the investor of the Megacorp. They don't need to be a party to this case. They
Yeah,
just
I'll accept your contention provided Megacorp Private Limited is one of the contracting parties. It is not.
Your lordship, it's right. Essentially,
See the clauses. It says everywhere applicable only to the contracting party.
your lordship, the reason that we have brought
for the purpose of compensation, you can't say that you cannot pierce the corporate wheel, and for the purpose of rigging this treaty, you turn around and say no, we follow
Your
the
lordship,
treaty.
the reason that we stated that the
Yes.
court cannot pierce the corporate veil is
Yes.
because it fails the ground of mere agency through established precedent.
Applicable when it comes to interpreting or understanding the treaty also.
The treaty, however, your lordship, is a foreign arbitral award. It determines a foreign arbitral award payable by the Union of India. I mean, by the Union of Aurora, your
Carry
lordship.
on. Yes.
Your lordship, if you look at Article 13.2, this very treaty expressly permits Aurora to regulate in response to new scientific evidence, changed circumstances, or international obligations. Professor Vega's report, if taken at face value, is that new evidence. A calibrated response to regulate, remediate, and supervise engages this provision directly. It is treaty compliant, it triggers no liability, and it protects the petitioners just as effectively as the cancellations, your lordship.
Now,
Your lordships.
we'll take it that the treaty is applicable. Now read clause 8.1.
If you just give me a moment to read clause 8.1, your lordships. Clause 8.1.
Yes.
Nothing in this treaty shall be constituted to prevent a contracting party from adopting or maintaining measures A. necessary to protect a human, animal, or plant life or health. B. relating to conservation of exhaustible natural resources. C. to maintain public order or essential security interest, your lordship.
So 8.1A will squarely apply. Necessary to protect human, animal, or plant life or health, and therefore Aurora can expropriate.
Your lordship, we beg to differ in this
Yes.
case. As necessary to protect human, that was a result of a freak accident, your lordship.
Yes.
Whether to say the accident will happen again with certainty is not possible. It is a freak accident, and it must be dealt as such with more supervision, which is again our overall contention. Same with animal. Your animal, I believe they are referring to the Aurora tigers, your lordship, and the petitioners had referred to M.K. Ranjit Singh versus Union of India, if I'm right.
See, we are dealing with human life. Can there be such a restricted interpretation?
Your lordship.
Simply because of the accident, lies lost. Even beyond that, if the project goes on, it will affect lives of many more.
Your lordship, we contend that it will positively affect. As Professor Vega's own report, the petitioner's own report, show that in a course of 100 years, 255 million tons of net savings of emissions are shown. In the sense, intergenerational
You can't
equity.
expect the present community to be there for 100 years. By the time
Your
they'll
lordship.
be wiped off, some will be displaced, the others will be wiped off because of the contamination. And you'll say in 100 years it will be offset.
Your lordship, dams regularly operate for long periods of
Yes.
times.
The dams are, but humans can't live forever to see the profits of what is being done now.
Much obliged, Your Lordship. That brings us to my next contention, that is the contradiction given by the petitioners.
Yes.
Essentially, when we talk about issue 4, Your Lordship, issue 4, it talks about intergenerational equity. In the sense, the rights of the future generations. The petitioners, and as we have conceded, if the court has decided to accept the rights of future generations, we would like to say that we are providing for that right. But when Professor Vega's own report, submitted by the petitioners themselves, show that we have a beneficial impact in the course of generations, the petitioners again claim short-term impacts are not followed. That is the main contradiction provided in issue 4, Your Lordship. Your Lordship, if we take, we know that it's established precedent that the state must protect their resources for future generation. That is established precedent, Your Lordship. But making that precedent into something, and I want to read the issue 3, Your Lordship.
That does not mean that the state should not preserve for the present generation.
Your Lordship, obviously they must refer.
They must. Yes.
Yes, Your Lordship. They must do this. And that is why we are building the EV vehicles.
Yes.
Their production is fairly quick.
EV vehicles caters to a particular group. But what about the persons who actually suffer on the ground?
Your Lordship,
You're not building or making these EV vehicles to supply to the tribals there.
Your Lordship, but
Yes.
the tribals will benefit from it
Yes.
because the benefits of climate change is felt by everyone.
Okay.
So at the end of the day, it is felt by every citizen of Aurora, every citizen of the world.
Okay.
Your Lordship, essentially, issue 4, it was not expressly elucidated by the petitioners.
Was
but
there a serious comparative study? The advantage of the project and immediate damage that may affect the human life and environment. Was there any comparative study?
Your Lordship, Professor Vega's report was in contradiction to that.
Read
But-
Vega's report and all. On the auspices of the government, was there any study?
Your Lordship, the studies has been what has been presented towards
You
the
are always
NGT.
saying that comparative hardship and comparative benefit. When you say that, you should be able to establish it.
Yes,
You
Your
should be
Lordship.
able to convince us.
Lordship, according to our NDC, National Determined Contribution, resulting from the Paris Agreement, Article 4, Your Lordship, we would like to show that the reason for why we have constructed this hydromine nexus is to achieve those goals. Achieve those goals which state that we must have more net savings. We must use renewable resources. We must use renewable energy. We must account for it. And that's the whole reason that this hydromine nexus project has been given. That's the whole reason in which we have gotten the
I'd
clearance.
rather ask the question because as Solicitor General, your contention all throughout has been regarding the benefits in future. Now, the question is whether there has been a comparative study regarding the immediate impact of this dam and the mining activity on the present generation. We're not about on the future generations.
Your Lordships,
Yes, the state is expected to do that, is it not?
Your Lordship,
Now,
for the question of
the profit or the finance shall not be the only consideration. Yes.
Your Lordship, for the question of immediate harm, we have gotten the environmental clearance after showing that it wouldn't provide for that which is irreversible. We said that we will reach carbon parity by the 18th year. Even though there will be net negative emission at the start, no environmental project has had a clear positive impact from the very beginning. So obviously there will be some net negative impact, but in the future, and this impact is not irreversible first. Second, when in continuation, in the course of generation, it provides a positive impact. And Your Lordship, we have conducted studies in A 3.3, the fauna, there are selected findings, Your Lordships. And in addition to this, up 8.5, pollution and health impact assessment. So we have conducted studies, and these studies are based on how we got our environmental clearance, as I just stated, Your Lordship. Your Lordship, coming to the wording of issue 4, which is quite fascinating here. They ask two things of this court, the petitioners. The petitioners have asked that the label of green infrastructure must actually deliver a net climate benefit. And the second request is that the public trust doctrine requires the state to maximize ecological benefit per unit of development, Your Lordship. I want to be very clear on the wording, ecological benefit per unit of development. Your Lordship, we'll first deal with the green label in infrastructure. Your Lordship, as I had just stated moments prior, that even green infrastructure such as the hydromine nexus, at the start, it may have some net negative emissions. So putting a blanket restriction such as it must only deliver net positive impact would be untenable, because there is no real environmental project that could only deliver a net positive impact from the very start of construction. Your Lordship. For that reason, this wording cannot be accepted. A blanket restriction cannot be placed. And the second one is even more egregious. The state, they must maximize ecological benefit per unit of development. Your Lordship, there is not a single precedent that shows that this must be done. In fact, in cases such as Lafarge, you may have referred to by the Attorney General, it has shown that compensatory afforestation must be done. Regenerative capacity of the environment must be restored. Those things are given, and we provide for that. VR, EMP, VR are further plans. VR, what we give to the tribals, we have provided for that. However, what is being sought here is something that is untenable, because it is frankly impossible, Your Lordship. Maximization
What
of
is your answer to their argument based on public trust doctrine?
Your Lordship, public trust doctrine does not stop all commercial activity. In the sense that for example, in Fomento Resorts case, they had stopped it there. However, this is a green infrastructure project. It seeks to deliver a net positive impact. Along with that, if we take into account Article 253 and our international obligations, we can see that this project has gotten the proper clearance to work. As in, the public trust doctrine is not being bypassed. And even if your lordships are in the view that it must have a net positive impact, that a green label must ensure a net positive impact. Professor Vega's own report show that we have a net positive impact over the course of generation, far exceeding what we have taken. And I want to end my arguments with one clear statement, Your Lordship. Your Lordship, we also want to state that if the project is cancelled, then the future generations inherit the consequences of energy poverty too. And this court's obligation to them runs in both directions, not just from the petitioners. In this case, it runs from the respondents as well. And with this, the Council for Respondents concludes its arguments advanced. And if no further questions come from the court, the Council would like to move on to the prayer. Much obliged, Your Lordship. Wherefore,
See, based on public trust doctrine and all, they contended that you have commenced a project without undertaking all the basic or satisfying all the basic requirements. They may even say that there were fraudulent acts for getting the sanction, getting it sanctioned and all. Now you come and say that if the project is stopped, it will affect the public in general and in the national interest. It has to be continued. How can this go
Much
together
obliged, Your Lordship.
when fraud is alleged? How can you get over
I'll be
on
happy
the national
to
interest?
answer your question here, Lordship. The fraud part, I believe, was dealt with my co-counsel, but I'll deal with the nature, the climate benefit part first. The main contention, the main disagreement the petitioners have is the fact that the Aurora tigers might go extinct. That is one of the main contentions, and we state that they won't. In MK Ranjit Singh, the court stated that it dealt with the Great Indian Bustard. They said that if the union continues with this project, this solar power project, then the Great Indian Bustard might go extinct. And the court in that case didn't stop the project. Instead, let's go ahead and give remedial measures. Let's ensure that the Great Indian Bustard does not go extinct. That is the same thing we ask here. If the court believes that the Aurora tigers are in even more danger than what we have already provided the remediation for, then the court can always levy further restrictions to ensure that the Aurora tigers are safe, Your Lordship. And similar to that, the net climate benefit, as I've already elucidated, is even their report says that it's a clear benefit for us, Your Lordship.
All right.
That is essentially our contentions for all four issues. If your counsel have no further, if the bench has no further questions, I'll move to the prayer. Much obliged, Your Lordship. Wherefore, in light of issues raised, arguments advanced, and authorities cited, it is prayed before this honorable court to dismiss the current petition and or pass any other orders as this court deems fit in the circumstances of the given case and in the light of good conscience, justice, equity. And for this act of justice, the Council for Respondents shall be duty bound and forever pray. It was an honor arguing before the honorable bench.
Your Lordship, for rebuttals, first and foremost, Your Lordship, in Annexure 7, the learned counsel, my friend, quoted that there will be a real-time pollution monitoring and other facilities will be given. The amounts will be settled. 1% of the benefit will be given to the tribal people. All these are just proposals. While my learned friends have taken initiative to construct a dam, their suggestions are still being proposed when it comes to welfare policies of the people. Now, second is my learned friend also mentioned the case called Orissa Mining Corporation versus Ministry of Environment, which is the very key case which upheld it that consultation should be the mandatory procedure. And third is, for the first time, I am seeing that the attorney, my learned friend, is taking a liability for a corporate company. So it is also important for us to understand the Annexure B13. The Annexure B13 very clearly says that it was not ex gratia amount was not satisfying the loss. If I like to draw your attention to Annexure B13, the people directly say that Megacorp ex gratia offer rupees 5 crores and equivalent to 25 lakhs for per family is refused by our community. This offer does not constitute acknowledgement of liability, does not restore a forest right, titles destroyed, settlement areas, and all these things. So that was not amounting to the loss which was suffered by people. And other important thing which I wanted to say is, my learned friend also made us to understand about the significance of EAA notification by referring to section 6. But important thing is the learned friend also should look on the same provision which learned friend was speaking about quorum. This quorum was not, it was not mandatory for the all this majority people. But the same provision also held that it is important for consultation, first point, which was not done. Second, district-wise notice, that was not done. Third is, when we question, the Honorable Court put forth a question, he said that the notice was published on internet. It is speaking about a tribal community which is in an ERR, and my learned friend is saying that internet notice was published along with that. This notice, okay, suppose consider that internet notice was published 5 days before the commencement of the event. That is the first question before notice. Second is that the council also said that the learned counsel for the petitioners pleaded for an independent interpreter. We did not plead for an independent interpreter. Nowhere I had mentioned that point. I had said that the interpreter appointed by the state was acting arbitrarily except translating. He was acting like a mediator and he was negotiating the problem. Further on, Your Lordship, I would like to draw your attention towards another important thing. Spoke about Forest Right Act. But Forest Right Act also speaks about section 6. He quoted section 6. Section 6 very particularly speaks that there should be a consultation between the forest ministry because you're converting 30 seconds, Your Lordship, 30 seconds. Because section 6 very clearly spoke that if you are converting a forest land into any other purpose, you have to have a consultation with the forest ministry. That was neglected. Along with that, public consultation, I cannot go into deep within this time span, but public consultation was completely violated. Along with it, Your Lordship, there's an important question on EAA itself. EAA is the very sole document which the counsel for the respondent relied on. EAA, the approval was granted by NERA on 20 December 2020. But the date written in EAA document in your hands, that is in Annexure A, it is 15 June 2024. 2 years of delay is marked there. And too much reliance on sustainable development is also given. You can see in the memorandum of the petitioners on page number 15. But it is important for us to understand in the Vellore Citizen Forum case, which the council themselves referred, it was held that the precautionary principle, polluter pays principle, along with sustainable development, should go hand in hand. With this, I conclude my rebuttals. Much obliged, Your Lordships.
The council will be dealing with in a point-by-point manner, as laid on by the petitioners. The first, starting with the very fact that the EMP is just proposals, Your Lordships. That is exactly what we can make right now. The entire point of the EMP is to be proposals. However, the court can definitely implement a monitoring committee to verify whether we are implementing it to the fullest extent. The second being, they have stated that it is not compensating for the loss. The fact that it is not compensating for the loss has not been determined by a judicial authority. It is being alleged on the respondents by the tribal people. And then further, Your Lordship, they have stated that a mandatory district by district notice has to be posted. It was placed in the district collectorate's office, Your Lordships. And then further, if we even set aside all of this, Your Lordships, the section 6A was dealt as well. The section 6 of the FRA only talks about how the Gram Sabha has to initiate the proceedings. Even if we leave aside all this, your lordships, here the issue is the dam. And if we take the most important case when it comes to dams, when it comes to environmental jurisprudence, which is Narmada Bachav Andolan, your lordships, in that specific judgment as well, if your lordships pointed out as well that the tribal people might not be alive at that point, your lordships, they have talked about the effects of constructing a dam as well. And in that specific judgment, they have clearly stated, merely because there is a change is no reason to presume that there will be an ecological disaster. And then further they have stated, the construction of a dam undoubtedly would result in the change of the environment, but it will not be correct to presume that the construction of the large dam like the Sardar Sarovar will result in an ecological disaster. Then what about the inundation or the submersion of the area? Your lordship, they have even stated about this as well. While an area of land will submerge, but the construction of the dam will result in multifold improvement in the environment of the areas where the canal waters will reach. Therefore, your lordship, the positive impact of the reservoir submersion has not been brought forth by the petitioners as well. Therefore, they are indulging in the same concealment activities that we are being alleged with. And then further, your lordships, come in the last important paragraph in 240. It states, in the case of projects of national importance where the Union of India and more than one states are involved and the project would benefit a large section of the society, and there is evidence to show that the said project has been considered over a period of time, which is the 2-year period where we conducted multiple impact assessments. And then further, the highest level of states in the Union of India, and more so when the project is evaluated and approval granted by the Planning Commission, then there should be no occasion for any court carrying out any review of the same or directing its review by any outside or independent agency or body, which Professor Vega here clearly falls under. With that, the council rests the submission in this present matter, your lordships. It is an honor.
Just on
Yes, your
aspect. Suppose at the end, if you feel that your offer of rupees 5 crore is totally insufficient, it is only a supposition. What is your offer then?
Your lordships, here in this present matter, now acting in the capacity...
We feel that it is totally insufficient.
Your lordships, here right now acting in the capacity of the respondents for Megacorp Private Limited, we would like to state before this honorable court that 5 crore is what we can provide as of right now. But if the court was to determine a quantum within the limits of a maximum of 7 to 10 crores, the company will be able to arrange for it. But then more than that would be indulging into the pockets of the company which is working for the country in the very first place, your lordships, by carrying out this specific project, the Hyderabad Nexus project, your lordships.
5 crores means rupees 25 lakhs per family.
Yes, your lordships.
Do you think that it is reasonable?
Your lordships,
Or even if it is 10 crore, do you think that it is reasonable?
Step into the shoes of the Attorney General and answer that.
your lordships,
You are
as the
representing
Attorney
the people
General,
of India.
this specific project, your lordships, if it was to be carried out for a commercial purpose, if the entire objective of this project was for a commercial purpose, and if such a blatant violation of safety protocols had happened, resulting in the deaths, we would have been, as the state, we would have provided even multifold amounts of, but the entire objective of this project, your lordships, is to work towards the environment. But this is a very, very unfortunate accident that we are we grieve a lot, your lordships, for this very unfortunate accident. But this is the quantum of ex gratia payment that is being provided by the company, your lordships. It is an honor, your lordships. Thank you.
The session has come to an end. The court is adjourned. All rise.
We have to be here.
I kindly request the participants to move outside the courtroom.
moot court competition, but a remarkable display of legal intellect, advocacy, and courtroom excellence. The finalists have presented themselves with exceptional confidence, and every moment of these proceedings have reflected the true spirit of the legal profession. I am Malavika Arun.
And I am Amal Ashok. As final year students of the 10th semester BA Honours and student coordinators of the BSOLS Moot Court Society, it is our privilege to be with you this afternoon. Before we proceed to the valedictory ceremony, we would like to take a moment to acknowledge the distinguished personalities whose wisdom, experience, and guidance have made this final round an unforgettable experience.
Every moot court is strengthened by the bench that presides over it. For the finalist, presenting arguments before such eminent jurists has been a rare privilege. For every participant and observer, today's proceedings have offered invaluable lessons and extend far beyond the competition itself. As a token of our sincere appreciation, Bharat Mata School of Legal Studies take immense pride in honoring our esteemed judges for their gracious presence and invaluable contribution to the first national moot court competition hosted by Bharat Mata School of Legal Studies.
May I first invite your attention to Honorable Mr. Justice V.G. Arun, former judge of the High Court of Kerala. His Lordship is a distinguished former judge of the Kerala High Court. Born on 25th of January 1964, he graduated in economics from Basilius College, Kottayam, and obtained his law degree from Kerala Law Academy, Thiruvananthapuram. He enrolled as an advocate on 8th of January 1989 and practiced in the civil and criminal courts at Kozhikode before shifting his practice to the Kerala High Court in 1990. He was also the editor of the India Law Reports before being elevated as an additional judge of the Kerala High Court on 5th November 2018 and becoming a permanent judge on 14th September 2020. Justice Arun retired from High Court in January 2026, leaving behind a distinguished judicial career marked by legal scholarship and dedicated service. May I respectfully request Reverend Father Dr. Joshi Pudua, Executive Director, BSOLS, to kindly present a memento to the Honorable Justice V.G. Arun. Thank you, Father.
Our next distinguished member of the bench is Honorable Mr. Justice P.G. Ajit Kumar, former judge of the High Court of Kerala. His Lordship had a distinguished career in the Kerala Judicial Service. He entered the judicial service after practicing as an advocate and served in various capacities, including as Munsif, Sub-Judge, Chief Judicial Magistrate, and District and Sessions Judge, earning recognition for his judicial competence and integrity. In recognition of his long and distinguished service, he was elevated as a judge of the Kerala High Court on 20th October 2021. Justice Ajit Kumar continues to contribute significantly to the administration of justice through his extensive judicial experience and commitment to the rule of law. May I now request Reverend Father Tony Manikithan, Assistant Director, BSOLS. In his absentia, I request Reverend Father Joshi Pudua, Director, Bharat Mata School of Legal Studies, to kindly present a memento to Honorable Justice P.G. Ajit Kumar, sir. Thank you, Father.
We are equally honored to have Honorable Mr. Justice C. Pradeep Kumar, former judge of the High Court of Kerala, with us today. His Lordship boasts extensive experience in both academia and judicial service. Born on 28th of May 1964, he obtained his BSc LLB and LLM from Government Law College, Thiruvananthapuram. After enrolling as an advocate, on 17th of December 1989, he served as a lecturer at Government Law College, Kozhikode. He entered the Kerala Judicial Service as a Munsif Magistrate in 1996 and was promoted as the District Judge in 2014. He served as a Principal District Judge at Talasheri and Kozhikode. He was elevated as an additional judge of the Kerala High Court on 25th of October 2023 and later became a permanent judge. His judicial career reflects decades of dedicated service to the administration of justice. May I respectfully request Reverend Father Dr. Joshi Pudua, Director, BSOLS, to hand over the memento to Honorable Justice C. Pradeep Kumar. Thank you, Father.
Honorable judges, your insightful observation, thoughtful questions, and encouraging guidance have enriched this competition in ways that extend far beyond the courtroom. The opportunity to appear before such an eminent bench is a privilege that every finalist will have throughout their professional journey.
On behalf of Bharat Mother School of Legal Studies, the Moot Court Society, and everyone present here, we extend our heartfelt gratitude for your invaluable time, encouragement, and support towards making the inaugural edition of our National Moot Court competition truly memorable. Thank you.